The gentleman from Florida is recognized for 5 minutes.
We are here at the hearing on the Manhattan District Attorney's Office, and the essential ingredient we seem to be missing is the Manhattan District Attorney, which I guess, Mr. Roy, would be a lot like going to the Salt Lick Barbecue and not getting the moist brisket. Now, to Mr. Jordan's credit, great credit, he sent a letter to Mr. Bragg on May 31st inviting him to come participate, and we got sort of a nasty gram back from Mr. Bragg on June 7th. Mr. Chairman, I seek unanimous consent to enter into the record the June 7th response from AG Bragg.
Objection.
And, I'm sorry, DA Bragg. And in this letter, I'm going to quote from it, Ms. Foley. Bragg says, "This office is committed to voluntary cooperation." Do you believe that?
No.
The letter continues, "That cooperation includes making the district attorney available to provide testimony on behalf of the office at an agreed upon date." Do you believe that?
I'll believe it when I see it.
It goes on to say that they're evaluating the propriety of allowing an assistant district attorney to testify publicly about the matter. Now, that assistant district attorney is the one who downstreamed from DOJ, right? So you think they're going to provide Mr. Colangelo here to answer our questions?
I would not expect Mr. Colangelo to show up.
And do you base that opinion on the lawsuit that Alvin Bragg filed against Jim Jordan in his official capacity in the Committee on the Judiciary?
I saw some of that, yeah. I mean, look, you have a legitimate legislative purpose to be inquiring as to what you're doing, so they have no leg to stand on.
But they're not going to come because we ask. And they're not going to come because they say so. And we learned that by observing our dear friends at the Oversight Committee. Because this will surprise a lot of Americans. After hearing the enthusiasm around oversight of the Biden crime family, we never sent a subpoena to Hunter Biden to give live testimony before Congress. Let that sink in. The Republican House majority has never subpoenaed Hunter Biden for live testimony in public. We've never done it. And I worry that, we're going about the same kind of process here, and we may end up there in July, right after sentencing, with an empty Alvin Bragg nameplate and an empty Matthew Colangelo nameplate. And then we'll start the process again on letters and subpoenas and accommodation, and I've just grown tired of it. And I think you're right, Ms. Foley, that this is all professional wrestling. There's no real effort to bring these people to bear. So,
will the gentleman yield for a
question? One second, I got a motion. Mr. Chairman, I move under Committee Rule 4 and Clause 2M of House Rule 11 to require the attendance and testimony of Alvin Bragg and Matthew Colangelo on July 12th to discuss their involvement in the Trump prosecution, including their office's coordination with the Department of Justice.
Mr. Chairman. Mr. Chairman.
Gentleman, ranking members recognized.
It's a little absurd because Mr. Bragg and Mr. Colangelo have already agreed to appear before the committee on July 12th. We have a letter to that effect, so there's no point requiring them to do what they've already said they're going to do. The committee asked them for to appear. They asked them to appear today. They made the point that or Mr. Bragg, I should say, made the point that he didn't think he should appear before the sentencing on July 11th, but he'd be available thereafter, and he's agreed to come on July 12th.
Mr. Chairman, this debate's out of order.
You made a motion. It's not out of order.
No, you have to seek recognition pursuant to debate on the motion. You can't just inject.
I recognize you.
I'm still on my time. I'm still controlling 2 additional minutes of time.
You'll get your time, man.
I have a letter here. No, my point is simple. The committee requested them to appear, Mr. Bragg and Mr. Colangelo. They've agreed to appear. They plan to appear on July 12th. I don't know what this debate is about. I yield back. Oh, and I'd like unanimous consent, Mr. Chairman. Yes, unanimous consent to introduce into the record a report from Fox News headlined.
Without objection.
I object pending consideration of my motion.
Hang on, I want to deal with.
Let me finish.
I want to deal with Mr. Gaetz' motion. Then we'll take your unanimous consent. Mr. Bragg and Mr. Colangelo have agreed to come on the 12th. If they don't show up on the 12th, they will be subpoenaed. So I would ask the gentleman if he could withdraw the motion. They're coming. We worked hard over the weekend to make sure they're coming. And if they change their mind, they will get a subpoena from the committee requiring them, compelling them to be here. And then if they choose to go to court on that, I think we'll beat them in court like we did the first time when we got Mr. Pomerantz to come testify in front of the, come be deposed in front of the committee.
Time then becomes determinative. The problem is, if we're going to bring these people in, let's go. I've made a motion to subpoena these people now pursuant to the rules, and I want to vote on my motion, or I want someone to move to table it.
You made the motion to subpoena them for the 12th?
I moved under Committee Rule 4, Clause 2M of House Rule 11.
I moved to
require the
table.
attendance.
I move to table the.
That's fine.
I
Let's take a
second
vote.
that.
That's not debatable.
Gentleman's made a motion. The motion to table is not debatable. Those in favor of...
This is crazy.
Committee will stand in recess. Commissioner Traynor, I want to read from your testimony. They have sat idly by and allowed a state officer to assert federal jurisdiction where they themselves had taken jurisdiction and couldn't prosecute. I want you to unpack that sentence for us again real quick.
Thank you, Mr. Chairman, for the question. The Department of Justice, all of these claims with regard to the $130,000 from Ms. Daniels stem from a complaint that was filed at the Federal Election Commission following the 2016 election.
Which you guys were investigating.
We were in the process of investigating that.
And the DOJ came to you and said, stand down, we're taking over, and give us your information.
They asked us to abate that and several other
DOJ
matters.
meeting the Southern District of New York.
That's correct.
They took your information, and you guys said, you voted to stand down and give it to the federal authority, right?
That's correct, Mr. Chairman.
And they determined that there was nothing there to prosecute other than Michael Cohen.
That's correct. Now, they took a very long time in doing it, and when they sent it back to us, we had no more authority to investigate because they sent it back to us, and we were barred by the statute of limitations from even investigating the normal civil things that we would look at with regard to those type of expenditures.
But your point here is they've sat idly by and allowed a state officer to assert federal jurisdiction where they themselves had intervened, to use the word, and taken jurisdiction from you and concluded there was nothing there regarding a federal statute, right?
That is
a, quote, federal crime that they come up with somewhere.
That is correct, Mr. Chairman, and I don't know what role Mr. Coangelo played in that investigation that took place when they took it away from the Federal Election Commission, did that investigation, and then he later left the office to go prosecute this at the state level.
Well, we're going to find that out on July 12th when Mr. Colangelo will be sitting in your seat, Mr. Bragg will be sitting in Ms. Foley's seat, and we'll get a chance to ask him. Mrs. Foley, excuse me, the Democrats talk about, jury of his peers. Okay, fine, that's how our system works. But if President Trump didn't learn what the unspecified crime was until the jury got the instructions from the judge, that sort of changes the dynamic a little bit, doesn't it?
Yeah, it's not blaming the jury. I mean,
of course.
The jury, has to operate according to the instructions provided by the judge. The poison here, the poison pill, are the jury instructions themselves, which provided the notice, but it came too late for purposes of due process. So, yeah, I mean, you can't correct that through a bad set of jury instructions. You know, if there's a due process defect because he learned too late, you have to redo the trial. You have to reverse the conviction, and then the prosecutor has to decide if they want to. Yeah.
I was an economics major. I mean, a major focused on wrestling, but you had to get a degree. I got one in economics, and they talk about this opportunity cost. If you don't know what the issue is, you miss the opportunity to maybe focus in on the issue as the defense counsel, right?
Yeah.
That's kind of important, particularly when you're talking about what kind of sentence they may try to impose on the president on July 11th. That's kind of important, right?
It's kind of important, and I would suggest that any member of this committee who faced similarly amorphous charges or a loved one would be absolutely incensed by facing these kinds of charges, where it was a moving target.
You're not the only constitutional scholar who's raised this concern, this, I think, huge concern. Mr. Dershowitz, Mr. Turley, I mean, other esteemed constitutional scholars have said the same thing.
I'm in good company. I think there's a general consensus that there are some due process problems here.
You sure are. Mr. Attorney General, July 15, 2021, Alvin Bragg. I'm the candidate in the race who has the experience with Donald Trump, and I think it'd be hard to argue with the fact that that'd be the most important, most high-profile case, and I've seen him up front and seen the lawlessness that he could do. That's what he said as a candidate. Does that fit with kind of the ethics of someone who's a member of the bar and running for a district attorney's position? Is that how you're supposed to conduct yourself in a campaign?
Absolutely not. That abhorrent statement is an incurable impropriety that should have disqualified Alvin Bragg from prosecuting that case.
Yeah. Not to mention, then when he gets the job, he looks at the facts, looks at all the evidence, and he concludes, like, this case, I shouldn't prosecute it. I should do what the Federal Elections Commission did, not prosecute. What the Southern District of New York did, not prosecute. What my predecessor, Cy Vance, did, not prosecute. That's what he wanted to do until the political pressure came. They talk about us all the time, pressure. Came from the left. Mark Pomerantz left his job, volunteered, goes and becomes an assistant district attorney to go after President Trump. And then when Alvin Bragg gets there and looks at how crazy the case is, and Michael Cohen's going to be their star witness, he goes, this is crazy. I'm not doing it. I'm not that crazy. But then they leak, Pomerantz resigns, leaks the letter, and all the left goes crazy. And Alvin Bragg says, now I'm going to do what I said during the campaign, even though I know it's wrong. And that's what happened. And then they got a judge who went along with all the crazy things Ms. Foley's pointed out. That's the story, and that story is consistent with the facts. That's why we're here today, and that's why we look forward to Mr. Bragg and Mr. Colangelo sitting right where you're at so they can answer our questions.